Okay. Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court today for what is called an arraignment. And what the arraignment is just an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies and misdemeanors. Now, your felony cases are normally referred to as your more serious type of offenses, whereas your misdemeanor cases are normally referred to as your petty offenses. Does not mean that they're not serious, it just means that they're not as serious as a felony case. Now, when I use the term serious, what I'm talking about the facts of the case, the possible punishment that a person can receive if they're convicted of the offense. And now felony cases are divided into 5 categories. We'll start at the top, work our way on down to the bottom. You have the capital murder, first degree felony, second degree felony, third degree felony, and the state jail felony. A person is convicted of a state jail felony. The range of punishment is minimum 6 months to a maximum of 2 years in the state jail and a fine that does not exceed $10,000. If a person is convicted of a third degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a second degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a first degree felony, the range of punishment is minimum 5 years to a maximum of 99 years or life in the state penitentiary and a fine that does not exceed $10,000. Now, if a person is convicted of a highest felony, the range of punishment is minimum life in the state penitentiary without possibility of parole or death by lethal injection. Now, as I mentioned to you earlier, your case is a misdemeanor case, so you don't have to worry about those type of punishments. Misdemeanors are divided into 3 categories. We'll start at the top, work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. If a person is convicted of a Class C misdemeanor, the range of punishment is by fine only. Now, Class C misdemeanors are cases that start in the city court or the JP court. They come to this court when they are found guilty in the JP court or the city court, and then they appeal their case. When they appeal their case, they get a whole new trial. We call it a trial de novo. And the case comes here, the punishment range is the same, and the punishment range is fine only. Cannot be given jail time for Class C misdemeanor. It's a fine only. Now, example of a Class C misdemeanor would be speeding, not having your seatbelt on, or maybe having expired inspection sticker. Now, those cases come to this court, and now I mentioned to you, you cannot get any jail time. However, if you fail to pay the fine, or if the fine was converted to community service, and you fail to perform the community service, then the court can issue what is called a capious pro fine. What that means is, it's a warrant for your arrest, for you either to pay the fine, or for you to sit the fine out in jail. And if you sit the fine out in jail, you will have $100 that will be credited toward your account, toward the payment of the fine and court costs for every 1 day that you sit in jail. Okay. Now, the next size misdemeanor is a Class B misdemeanor. With the Class B misdemeanor, the range of punishment is minimum 0 days to a maximum of 180 days in the county jail. Or you could be given a fine that does not exceed $2,000, or you could be given both such jail time and a fine. Now, the highest misdemeanor is a class A misdemeanor. And with the class A misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days, which is a year in the county jail. Or you could be given a fine that does not exceed $4,000, or you could be given both such fine and jail time. Now, you may be eligible for probation. There are two types of probation. One type of probation is called unadjudicated probation, and the other type of probation is called adjudicated probation. Now, the difference between the two is as follows. With the unadjudicated probation, we commonly refer to it as deferred probation. It does not result in a conviction on your record. And if you successfully complete it, the case will be dismissed. And you can get what is called a non-disclosure. A non-disclosure means your record is sealed to the general public. So the general public cannot have access to your record if you get a non-disclosure. However, the operative word that I used was general public. The rest of the public, the rest of the public, I'm talking about, there are certain governmental agencies that are listed in the Texas Code of Criminal Procedure that can have access, like the police department. Okay, but most of the public is general public, so they cannot have access. You apply to a job, ExxonMobil, and you have a non-disclosure. They do a criminal background check. Guess what? They can't see it because it's sealed to them. Now, the next type of probation is called adjudicated probation. The last one was unadjudicated. Now we have adjudicated probation. With adjudicated probation, it does result in a conviction on your record. However, there is something that is called judicial clemency. What that basically means is like the judge, the judicial fix, the judge can give you a pardon. Okay. It's called judicial clemency, where the judge can set the conviction aside, and you will no longer have its conviction on your record. And so if somebody go and look for it, it's not there because you got judicial clemency. However, if you get a subsequent conviction later on, in essence, you get another conviction later on, what can happen is the case that you received judicial clemency on, it can be resurrected, revived, brought back up, and it can be used against you. So if you try to get a license with Child Protective Services, they can deny giving you a license, or if you have a license, they can revoke or suspend your license. Now, everyone here for a case should have a clipboard. Who does not have a clipboard? Who's here for a case and do not have a clipboard? Okay, so everyone have a clipboard. Okay, so I'm going to go over the information that's on that clipboard. Now, the first long page, I'm not talking about the little short sheet. The first long page should be titled Judge's Explanation of Rights to Defendants Without Attorney. It looks like this. Okay, it looks like this. Judge's Explanation of Rights to Defendants Without Attorney. Now, I'm going to go over this sheet. I will constantly refer back and forth to the sheet. This sheet states that as a defendant in a criminal case, you have three options. Number one, you may hire an attorney. Number two, you may request or ask that an attorney be appointed to represent you. And number three, you may represent yourself. Those are your options regarding your right to have an attorney. Now, the first one sentence paragraph below number three states that if you want an attorney and you have enough money to hire an attorney, your case will be reset. Reset means you're given another court date to give you time to hire your attorney. The next one sentence paragraph below that sentence states that if you want an attorney, but you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you, but you must first fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. Now, this is only for people who will be applying for a court-appointed attorney. So if you're not applying for a court-appointed attorney, you don't have to worry about anything that I'm getting ready to say. Okay. For those individuals who are applying for a court-appointed attorney, you would have to fill out this document that is titled, it's a 3-page document that is also on the clipboard, and it is titled Jefferson County Affidavit of Indigence. Now, this is only for people who will be applying for a court-appointed attorney. Now, you would have to fill out the entire first page, okay? And then you go to the second page, and at the top of the second page, it says Defender's Oath at the top. You'll fill out that little portion right there. And then you'll fill out the middle portion that's titled Unsworn Declaration by Defendant in the middle section, and then you'll stop. That's on page 2. So on the first page, you fill out the entire first page. And then you go to the second page, you'll fill out the top portion that says Defendant's Oath, and the middle portion that says Unsworn Declaration by Defendant. Now, going back to the first form, there's an explanation of rights to defendants without attorney. The next one-sentence paragraph states that you may not speak to the prosecutor about your case unless you first sign a written waiver of your right to be represented by attorney. This sentence is only for people who will be representing themselves. Okay. You have a right to hire an attorney, you have a right to ask for a court-appointed attorney, you also have a right to represent yourself. If you represent yourself, you are your own attorney. And so just like your attorney can talk to the district attorney or assistant criminal district attorney about your case, you can talk to the assistant criminal district attorney about your case. Why? Because you're your own attorney. You represent yourself. Okay? And we have one assistant criminal district attorney that's in court. Mr. Attorney Benitez Williams.
Good morning, y'all. Good morning.
Now, if you represent yourself, you have an opportunity to talk to him about your case to see if y'all can work out a settlement. We call it a settlement, but it's called a plea bargain agreement. It's a way where you settle your case. Okay, if you're able to work out a settlement or plea bargain agreement, you'll be talking to that judge. All right, now that's only for people who will be representing themselves. And if you are representing yourself, there's a paragraph here in block form, is below the second one-sentence paragraph, and it states, be aware that the dangers and disadvantages of self-representation, waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities related to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, this last one-sentence paragraph at the bottom down here states, and this is for individuals who are representing themselves. If you're representing yourself, you may change your mind at any time and request that an attorney be appointed to represent you. So what that means is this: let's say you represent yourself, and let's say you want to work out something with this district attorney. In your mind, you say, well, I want to see if I can get probation. Okay. And you talk to the prosecutor, assistant criminal district attorney, and they say, well, we want to offer you a fine. You don't want a fine, you want a probation. Or they might say, well, we're going to offer jail time. You don't want jail time, you want probation. Or you can say, well, Judge, I changed my mind. I don't want to represent myself. I want to apply for a court-appointed attorney. So this sentence is basically saying that if you represent yourself, you may change your mind at any time and request that an attorney be appointed. Okay? Now, at the bottom of this document, in bold letters, it says defendant's choice. Mark your initials next to only one choice. So what they're talking about down here, we have 5 lines to the left at the bottom of this document. Everyone here is gonna make a choice on one of those lines. Okay. If you would like to hire your own attorney, then you'll place your initials on the first line to the left of this document at the bottom. And then you'll sign this at the bottom where it says defendant, dated today's date. And then you'll stop. This is all you have to sign. Then you'll stop. If you have already been appointed, well, if you have already hired an attorney, okay, if you have already hired an attorney, then you'll place your initials on the second line at the bottom to the left, and the name of the attorney on the line to the right. You'll sign where it says defendant, dated today's date, April 14th, then you'll stop. This is the only form you have to sign. If you would like to apply for a court-appointed attorney, then you will place your initials on the third line at the bottom, down here, the third line. You will sign this document that says, where it says defendant, you will date it today's date, April 14th, and then you'll go to the next form that's titled Jefferson County Affidavit of Indigence. You fill out the first page, go to the second page, fill out the top portion where it says defendant's oath, and the middle portion it says unsworn declaration by defendant, and then you'll stop. If you have already been appointed a court-appointed attorney, in this case, then you'll place your initials on the fourth line to the left at the bottom, and the name of the attorney on the line to the right. You will sign where it says defendant, you will date it today's date, and then you'll stop. This is the only form you would have to sign. Now, if you would like to waive your right to an attorney, that is, give up your right to an attorney, you would like to represent yourself, then you'll place your initials at the bottom, the last line at the bottom where it says, I waive my right to an attorney and I desire to represent myself. So you'll place your initials on this fifth line, your initials. And then you'll sign it where it says defendant. You will date it today's date, April 14th. And then you go to this form that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. This is only for people who will be waiving their right to learn. And these are individuals who will be representing themselves. You have to read this form, sign it where it says defendant and date it today's date, and then you stop. Okay. Do we have any questions before we go on? You have a question? Anybody have any questions? Okay, no questions. All right. Now, I'm going to give you time to finish filling out the paperwork. The next thing I need to talk about, or the next right I need to inform you about is your right to have a jury trial. Okay? The area over there, we call it the jury box. They have 12 chairs, but in county court, you only have 6 on your jury. So 6 citizens from Jefferson County will be selected to serve as jurors in your case. They will listen to all the evidence that's presented by the state and by the defense. They will listen to the arguments of the state and the defense, and then they will go back into the jury room behind those doors. They will deliberate, and they can either find you not guilty or guilty. You also have a right to waive or give up your right to have a trial by jury. By waiving or giving up your right to have a trial by jury, you're saying that I don't want to have a trial by jury. I want to have a trial, but I don't want to have a trial by jury. So, well, if that's the case, you can have what is called a bench trial. What that means is a trial by judge only. The judge will be the judge and the jury in the case. The judge will listen to the evidence presented by the state, the evidence presented by the defense, the arguments of the state, the arguments of the defense, and then the judge will apply the facts of the case to the law and decide whether to find you not guilty or guilty. And you can waive your right to have a trial by judge as well. And if you get to not having a trial by jury, not having a trial by judge, then you're at the position where you enter in a plea basis. And so a person can enter one of three types of pleas. They can enter a plea of not guilty. If they enter a plea of not guilty, they tell the court that they did not commit the offense that they've been charged with. That's why we have trials. And if they can enter a plea of guilty. If they enter a plea of guilty, they're telling the court that they committed the offense that they have been charged with. Or they can enter a plea of no contest. They enter a plea of no contest and telling the court that they will not be contesting or they will not be fighting the charges. Now, if they enter a plea of guilty and no contest, and they would like to work out a settlement of the case with the district attorney, we call that a plea bargain. There are two types of plea bargain. One type of plea bargain is called, that door is locked, sir. One type of plea bargain is called an agreed plea bargain. And the other type of plea bargain is called an unagreed plea bargain. With an agreed plea bargain, that just simply means that you and the state has reached an agreement on the case. You want probation, now for probation, you got an agreement. And so if you reach an agreement, then it has to go before the judge, and the judge can do one of two things. The judge can accept or reject your agreement. Now, if the judge rejects the agreement that you made, you wanted probation, state offer you probation, it goes before the judge and say, Judge, I'm not following an agreement. Or you can tell the judge, well, since you're not following the agreement, I withdraw or I take back my plea of guilty, no contest. You have a right to do it if the court does not follow your plea bargain agreement. Now, if the court does follow your plea bargain agreement, and let's say within 30 days, and the reason why I say 30 days is because within 30 days, you can file a motion for new trial or an appeal. So if you file an appeal, if you want to file an appeal, you have to get permission from the judge that followed the plea bargain agreement. And if the judge gives you permission, your case is going to leave this court. It's going to go upstairs to the Ninth Court of Appeals. There are about 4 judges up there that will review your case. They can do one of two things. They can accept or reject, well, they can grant or deny your appeal. If they grant your appeal, they can look at it and just simply find you not guilty, case over. Or they can send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal, guess what? You can appeal your case to a higher court than the Ninth Court of Appeals. You can appeal your case to the highest criminal court in the state of Texas. It is called the Texas Court of Criminal Appeals, located in Austin, Texas. And you have to file what is called a pro se petition for discretionary review. I will explain it to you. Pro se means self. I'm representing myself. I don't have a lawyer represent. And I'm petitioning the court. That is, I'm asking the Court of Criminal Appeals to review my case to see whether or not this court committed an error by convicting me, or the Ninth Court of Appeals, whether they committed an error by denying my appeal. They can do one or two things. They can grant or deny your petition. If they grant your petition, they can simply find you not guilty and the case is over. Or they can send the case back to the Ninth Court of Appeals with orders, or send it back down to this court with orders. Now, if they deny your petition, then at that point, your conviction will stand. Now, the other right that you have a right to have witnesses to come to court. And witnesses sit in that chair where we have the microphone in front. And what witnesses do, they can testify for you, against you. If you're representing yourself, you can ask them questions. Or if you have a lawyer representing you, a lawyer can ask them questions. We call that either direct examination or cross-examination. Now, you can waive or give up your right to have witnesses to come to court. And if you do that, that means you will not be calling witnesses. It does not mean that the state will not be calling witnesses, because they will be calling witnesses in the case. The other right that you have a right, it's called a Fifth Amendment right against self-incrimination. Let me explain that to you. The Fifth Amendment of the United States Constitution gives us, all of us, a right to remain silent. Okay? The state, the government, the district attorney cannot force you to take a witness stand and testify against yourself. And if you think about it, it makes sense. The reason why it makes sense is because the state of Texas has the burden to prove that you did what they say you did. They have to prove the case beyond a reasonable doubt to a jury or judge that you committed this offense. You don't have to prove yourself guilty. All right? You don't have that burden. They have the burden. They filed the charges, so they got to prove it. You don't have to prove it. All right. Now, you can waive or give up your Fifth Amendment right against self-incrimination. What that means, if you do so, you will be testifying in your case. The other right that you have a right to have discovery. And what discovery is, it's a right to see what's in the state's file. Okay? You have a right to see witness statements, your statements, police reports, lab reports, photos, video recordings, the audio recordings, documents. You have a right to have access to any documents or instruments that they have. That's called discovery. You have a right to see that. I'll have access to it so that you can prepare for the case, your defense. Okay? Now, you can waive or give up your right to have discovery, which means you said, I don't want to see them. You have a right to do that. Now, everyone that's here today, you have had charges filed on you, you've been arrested, been booked into the county jail, you've been released on bond, you're either out on a cash bond, which means you pay the full amount of the bond to get out of jail. You're out of jail on a surety bond, which means you pay a bondsman a percentage of the bond to get out of jail. Or you're out of jail on a PR bond or a personal recognizance bond, which means that you didn't have to pay no money to get out of jail. You was just released under your own personal recognizance with a promise to appear here today. Now, I've said that to say this. Every day that you spent in jail can be used as credit towards your punishment. Now, the operative word is every day. Let me explain it to you. Let's say you were arrested at 11:59 p.m. last night, and you were released at 12:01 a.m. this morning, 2 minutes later. You get credit for 2 days. Why? Because it's 2 different days. One day was Monday, the next day was Tuesday. So that's 2 days. You have to be there 48 hours to get credit for 2 days. Okay? So the point is to say, let's say you spend 5 days in jail. The state is offering that you serve 5 days in jail. Guess what? You don't have to serve no more time in jail. Why? Because you'll be given credit for the time that you've already served. Now, if they're offering 7 days in jail and you spend 5 days in jail, that means you only have to spend 2 days in jail. Why? Because we'll subtract 5 from the 7 and leaves 2. Now, every day that you spent in jail, you are credited $100 per day that will go toward the payment of your fine and court costs. So, for example, state is offering you fine and court costs, settle the case, of $500. You spend 5 days in jail, you don't have to pay anything. Why? Because the time that you spent in jail has already paid it off. And we say it's tax and retire. Now, if they're offering $700 fine and court costs, that means you don't have to pay $200. Now, you have to pay $200 on the day that the case is taken care of. If you cannot pay it, no problem. We can put you on what is called a payment plan, where you can pay it off in small monthly installments. Now, if you cannot pay it off in small monthly installments, no problem. Because we can convert the fine and court costs to community service. So for every 1 hour of community service that you perform at a nonprofit organization in our community, you will be credited $12.50. So in our scenario, you owe $200. If you work 8 hours one day, community service, that's $100. So if you work 2 8-hour days, that's $200. Guess what? Your fine and court cost balance is paid off. All right. Now, Jefferson County has a program for first-time offenders. Let's say you haven't had any trouble with the law first time, getting one or more cases. There's a program that the district attorney's office has that's called pretrial diversion. They will dismiss your case. And you can get it wiped off your record. We call it expunge. In order to qualify for the program, it has to be your first time getting in trouble with the law. Okay? You might have one or more cases, but it's your first time. And 2, you have to have an attorney to assist you with the application process. The attorney could be court appointed. You don't have to hire one if you can't afford to hire one. And the other thing, it cannot be for an offense involving resisting arrest or unlawfully carrying weapons. So for all other offenses, you can, if you're eligible, you can apply for pretrial diversion, get into the program, complete the program, then dismiss the case, you can get it wiped off your record. And so when somebody going to do a criminal background check, guess what? It's clear. Never happened. All right. Now, if you're a veteran of any one of the branches of the United States military, the district attorney's office has another program for veterans. It's for veterans only. It doesn't matter what kind of case it is. You just have to be a veteran. And with that program, you enter into the program, you complete the program, then what they will do is dismiss the case, and you can get it, get an expunged, but it won't be able to break. Okay? Only way to get in, just be a veteran of any one of the branches. All right. The next thing, this court, County Court at Law Number 2, has a program that is called the CSI program. It is a program that God led me to start in the first 100 days of taking office in March of 2017. That program is designed to address the issue of what is called recidivism. I explained it to you. Recidivism means people commit crimes over and over. Okay, it keeps reoccurring. And so to address the issue of recidivism, God led me to start the program that is called the CSI program. CSI stands for Community Safety Initiative. And in that program, we have partnerships. We have partnerships with various agencies. One of the agencies that we have a partnership with is Spindletop Center. Spindletop Center is our local mental health center in the Southeast Texas area. And what Spindletop will do, well, first of all, Spindletop has the expertise to address mental health issues. Now, you don't have to be incompetent or insane to participate in the program. You could merely suffer from anxiety or depression or any other host of mental illness. And they have the expertise to address your issue. And basically what Spindletop will do, they can conduct a private interview with you either in our jury room, in their facilities, by telephone or by text, whichever is convenient for you. They will also be able to diagnose what your mental health illness is. Okay? That is, they'll be able to do an assessment. And then they could develop a treatment plan for either outpatient or inpatient treatment. If you have problems or issues with drugs or alcohol, Well, we have a partnership with our local drug and alcohol council that has a program that is called OSAR. It's OSAR. It's an acronym that stands for Outreach, Screening, Assessment, and Referral. We also have the partnership with Spindletop that has a drug and alcohol recovery program that is called ATAR. ATAR stands for Addiction Treatment and Recovery. Both of those programs are drug and alcohol recovery programs. And basically what they would do a screening and assessment to determine what your issues are with drugs and alcohol, or drugs and alcohol. And they could develop a treatment plan for either outpatient or inpatient treatment. If you are unemployed, or if you're looking for a better job, we have a partnership with the Golden Triangle Empowerment Center. We have a partnership with Lamar University. And Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the chemical industry, and the shipping industry. Once you're trained in any one of those areas that you select, they will help you to get a job in the area that you're trained in. If you have not graduated from high school, or if you do not have a GED, a graduate equivalency diploma, well, CICE as well as Spindletop have, both programs have GED program where you can get your graduate equivalency diploma. Now, all of these programs that I just mentioned to you are free. Does not cost you anything but time. And I like to say in this quote, we don't just give time. We take our time. That is, we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I like to say that when you come to County Court at Law Number 2 in Jefferson County, Texas, we don't just have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that comes before this court. And if we make a difference in their life, we'll make a difference in their home. And if we make a difference in their home, we'll make a difference in the community, because what comes out of the home goes into the community. And so if you're interested in any one of these programs, just let us know. And we'll be happy to direct you to the people that you need to talk to so that you can get on the road to living your best life. Okay. So at this time, we're going to go into recess in a few minutes. Now, I failed to mention that on the top of that document, that first document, it says the state of Texas versus, and then there's a line. Please print your name on that line. Because if your handwriting is like mine, sometimes I can't even read it. Just print your name on it so that we'll know who the document or who the form is for. Now, we're going to pick up those documents from you. We're going to put you into one of 3 categories. If you are hiring your own attorney, your case will be reset today. That is, we'll look at it, make sure everything is right. We'll give you another court date, give you time to hire your attorney. If you would like to apply for a court-appointed attorney, if you qualify, your attorney will be appointed the day before you leave. And so you'll know who your attorney is before you leave the courtroom. Or if you would like to waive your right to an attorney and represent yourself, then you'll have an opportunity to talk to the prosecutor to see if you can work out a settlement or a plea bargain in your case. And if you're able to work out a plea bargain, your case will be taken care of today. Now, we're going to pick up those documents from you. It's gonna take us a few minutes to pick them up. If you need to use the restroom, there are two restrooms right outside in the hall. The men's restroom is in front of you. County Court at Law number 3. And the women's restroom is on the opposite side of the hall, in front of the 172nd District Court. Now, you'll be allowed to use the restroom. When you use the restrooms, please come back in the courtroom, because if you leave the courthouse and if your name is called, you're not here, your bond is going to be forfeited. A warrant can be issued for your arrest. Guess what? You'll be arrested, placed in the Jefferson County Jail. You're gonna have to bond out, and guess what? We're gonna have to go through this all over again. Okay? So we don't want to do that. We're gonna try to get you in and out of here as soon as possible. And so, if you need help filling out the paperwork, we have our court personnel, including myself, who will be happy to assist you with filling out the paperwork. So before we go into recess, let me inform you that we're still in court. So continue to conduct yourself accordingly. All right? Do we have any questions? No questions? Okay, no questions? All right. So we're gonna go into recess, and if you need help with your paperwork, just raise your hand and let us know, and then we'll be happy to help you. Yes, you have a question?
Yeah, so on that first chance, I guess I wasn't qualified, but I've been on probation for the first Tuesday, but I completed it. But it was,
Oh, you're talking about the pretrial diversion program?
that was like 15 years ago.
Yeah, now if you, I know if they say for first time offenders, but if you have an attorney, maybe your attorney may still apply, you never, I know, yeah. I just know that there's a, that program. Okay, anybody else? Yes,
Do you need to see an attorney for pretrial diversion?
you have to have one to assist you with that, they require that you have one to help you with this, application process, because what's gonna happen is if you get approved for pretrial diversion, you're gonna go to the district attorney's office. There's gonna be a group, you're gonna meet with the district attorney, the assistant district attorney, as well as the probation department. And there's some documents, some legal documents that has to be signed. And so I guess your attorney is there to make sure they can explain everything to you. Okay. Okay, but like I said, your attorney don't have to be hired. If you can't afford to hire one, you get, if you qualify, your co-appointed attorney can apply. Okay? Yes, anybody else? Okay, at this time, we're going to go into recess, and again, make sure you conduct yourself accordingly, and then we're gonna call you up one at a time, so we can, go over the paperwork. We will try to get you in and out as soon as possible. Court is in recess.
Make sure you complete your paperwork before stepping out, going to the restroom, going with. If not, you're gonna prolong your stay.
Jefferson County Court at Law number 2 is back in session. The court is in session. And cause number 26 CCCR 0448. Case is style, the state of Texas versus Miguel Lorenzi Jr. Mr. Lorenzi, would you please come forward? Mr. Lorenzi, your full name is Miguel Lorenzi Jr.
Yes, sir.
Mr. Lorenzi, would you please raise your right hand? Mr. Lorenzi, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You may put your hand down. How are you doing?
I'm doing good today, sir.
I'm doing, that's good. Now, Mr. Lorenzi, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that state you'd like to hire your own attorney?
Yes, sir, that's correct.
Okay, Mr. Lorenzi, before you signed this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Lorenzi, I read your answers. Your case will be reset to give you time to hire an attorney. Our court coordinator is going to reset your case. Once your case is reset, you're free to go and you have a blessed day. Please stand in front of the court coordinator.
Yes, sir. I have a question. Could she give me some kind of paperwork showing that I was here today?
Is Jennifer do that? You can do it?
Yeah.
Okay, just stand over there. in front of the coordinator.
No, man.
Next case is cause number 26 CCCR 0496. Case is styled the state of Texas versus Jayla Monet Dixon. Ms. Dixon, your full name is Jayla Monet Dixon. Ms. Dixon, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, Ms. Dixon, you may put your hand down. How are you doing, Ms. Dixon? I'm doing fine, thanks for asking, Ms. Dixon. I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Is this your signature on the line that's titled defendant?
Yes.
Are these your initials on the line that states you'd like to have your case reset to hire your own attorney?
Yes.
Now, before you signed this document, did you read the document? Did you understand what you read?
Yes.
Is everything in this document true and correct to the best of your knowledge?
Yes.
Okay, Ms. Dixon, I read your answers. Your case will be reset to give you time to hire an attorney. Our court coordinator will reset your case. I think she's already reset.
Yeah.
You can get your reset from the court coordinator. Once you get your reset, you're free to go and you have a blessed day.
Thank you. Take the person up. I mean, unless you want to leave Have a good one.
Bless you. Next case is cause number 26 CCCR 0430. Case is styled the state of Texas versus Christopher B. Host. Mr. Host, your full name is Christopher
Brent. Brent. Yeah.
Christopher Brent Host.
Yeah.
Okay, Mr. Host, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Host, you may put your hand down. How are you doing, Mr. Host? I'm doing fine, thanks for asking. Now, Mr. Host, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes,
Is this your signature on the line that's titled Defendant?
yes,
And are these your initials on the line that state
yes,
that you like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence.
yes,
Do you recognize this document?
No.
On page 2 of this same document, there's a signature above the line that's titled Defendant Signature. Is this your signature?
yes,
Now, Mr. Host, before you sign, initial these documents, did you read the documents?
I did.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yeah.
Mr. Host, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Jack Lawrence. Attorney Lawrence will be given information to contact you, and you will be given information to contact him.
Okay.
Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day.
Yes, sir. Thank you, Judge.
You're welcome. Timothy Neal Jean. Mr. Jean, your full name is Timothy Neal Jean.
Yes, sir.
Mr. Jean, would you please raise your right hand and you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Jean, you may put your hand down. How are you doing, Mr. Jean?
I'm doing fine, sir.
That's good, man, Mr. Jean. I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled
Yes,
Defendant?
sir.
And are these your initials on the line that state you like to apply for court-appointed attorney? I also have another document that's titled Jefferson County Affidavit of Indigence. You recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Now, Mr. G, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yeah.
Is everything in these documents true and correct
Yes, sir.
to the best of your knowledge?
Yes, sir.
Okay, Mr. Jean, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Todd LeBlanc. Attorney LeBlanc will be given information to contact you, and you will be given information to contact him.
Yes, sir.
Our court coordinator will give you that information. Once you get that information, you'll be free to go, and you have a blessed day. Please have a seat in that first chair on the wall.
Where was it? No, I wouldn't. Last week. Last week, I'll be on tour.
Jason Bradley. Mr. Bradley.
Yes.
Your full name is Jason, is that Jason Thomas Bradley?
Yes, sir.
Mr. Bradley, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Bradley, you may put your hand down. How are you doing, Mr. Bradley?
Doing good. How about you?
I'm doing fine, thanks for asking. Mr. Bradley, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that states that you'd like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that is titled Defendant's Signature. Is this your signature?
Yes, sir.
Now, Mr. Bradley, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Bradley, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in your case is Attorney John Macy. Attorney Macy will be given information to contact you, and you will be given information to contact him.
Yes, sir.
Our court coordinator will give you that information. Once you get that information, you'll be free to go. And you have a blessed day.
You too.
Please have a seat in that second chair on the wall.
Yes, sir.
Yasmin Nicole Crane. Ms. Crane, your full name is Yasmin Nicole Crane? Yes. Ms. Crane, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Crane, you may put your hand out. How are you doing, Ms. Crane? Fine. I'm doing fine. Thanks for asking. Now, Ms. Crane, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? On the next document, this document is titled Jefferson County Affidavit of Injuries. Do you recognize this document?
Yes.
On page 2 of this same document, there's a signature above the line that is titled Defendant's Signature. Is this your signature?
Yes.
Ms. Crane, before you sign and initial these documents, did you read the documents? Did you understand what you read?
Yeah.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
And Ms. Crane, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Lori Perazzo. Attorney Perazzo will be given information to contact you, and you will be given information to contact her. Our court coordinator will give you that information. Once you get that information, you'll be free to go, and you have a blessed day.
You too.
Have a seat in that third chair on the wall. I need some, those bond conditions. Thank you. Hmm? Yes.
This is your next court date, the second felony case, okay? He should be contacting you within 24 hours, but if he doesn't, and you have questions, this is the information. Thank you.
You can see me first. Yeah. Yeah.
Mr. Did I pronounce your last name right?
Coffin, yes, sir.
Coffers? Okay. Your full name is Clint Michael Coffers.
Yes, sir.
Mr. Coffers, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Coffers, you may put your hand down. How are you doing, Mr. Coffers?
Pretty good.
I'm doing fine, thanks for asking. Now, Mr. Coffers, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Let me sign it. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. You recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that is titled defendant signature. Is this your signature?
Yes.
Now, Mr. Coffers, before you signed and initialed these documents, did your attorney, did you read the documents?
Yes, sir.
And did you understand what you read?
Yes, sir.
And is everything in these documents true and correct
Yes, sir.
to the best of your knowledge?
Yes, sir.
Mr. Coffers, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney David Grove. Attorney Grove will be given permission to contact you, and you will be given permission to contact him. Our coordinator will give you that information, but before she gives you this information, I need to give you some bond conditions. Step, here you go, you can take those, you can stand back to in the same place you were standing. Now, I'm going to go over this document with you. And it's titled Standard Bond Conditions in County Court at Law Number 2. And it states following return of criminal information in County Court at Law Number 2 of Jefferson County, Texas. All bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And the next condition states that the defendant shall not communicate either directly or indirectly with the alleged victim, and the alleged victim in this case is Judy Coffers of the pending offense, and the defendant shall not go to any residence, school, or other location frequented by the alleged victim, and that's Judy Coffers. Do you understand that?
So that was only supposed to be for 90 days.
Well, that was the temporary order
Okay,
that you received. That these are bond conditions. Okay,
okay.
and these bond conditions gonna stay in effect until this case is disposed of.
So that means that now I can't communicate again with my mom? Is that what that's saying?
You cannot communicate either directly or indirectly with the alleged victim of Judy Coffers of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim, Judy Coffers. Okay,
Okay,
now do you understand that condition?
yes.
And let me see, okay, now let me Ms. Mosby, I need to see his bond condition. I need to write the name on his, Judy Coffers. Now, the next condition doesn't apply, that's condition number 4. Condition number 5 does apply. Condition number 5 states, defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes.
And condition number 7, that's on here, states that defendants shall wear a global positioning monitoring system. It's commonly referred to as a GPS device at the defendant's expense, with written verifications being submitted to the court within 3 days. Do you understand that condition?
Yes.
Okay, now if you violate any one of these conditions, your bond can be revoked, and if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. You're gonna have a seat in that Clint coffers. You'll have a seat in that first chair, wait for your name to be called. She'll give you your reset plus information on where you can get your GPS in. Okay. We have any? Please read it.
We have 2, I don't know.
Sydney Jones, calls number 266 CCCR 0396.
First right there. Yes, ma'am. Thank you.
This is cause number 26 CCCR 0396. Case is style of state of Texas versus Sydney Jones. Hey, Ms. Jones, is that your full name?
Yes, sir.
Ms. Jones, would you please raise your right hand? Swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Ms. Jones, you may put your hand down. How are you doing, Ms. Jones?
I'm good. How are you?
I'm doing fine, thanks for asking. Now, Ms. Jones, I have before me a document, 2 documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Well, before we go any further, now, Ms. Jones, you have a right to have a record made of this proceeding. That is, you have a right to have a court reporter to dictate down everything that's being said. You also have a right to waive or give up your right to have a court reporter. Do you waive or give up to have a court reporter? You do? Now, Ms. Jones, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? And is this your signature on the line that's titled Defendant?
Yes, sir.
Are these your initials on the line that state that you would like to waive your right to an attorney and represent yourself?
Yes, sir.
I also have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Now, before you sign and initial these documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Now, Ms. Jones, I have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Stephanie Jones, on or about December 18th of 2025, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of theft.
I gave you the information.
Do you understand what you have been charged with?
Yes, sir.
To this charge, how do you plead guilty, not guilty, no contest?
Guilty.
Now, you're pleading no contest freely and voluntarily?
Yes.
And are you pleading no contest because you do not wish to fight or contest the charges? And Ms. Jones, I also have before me on my computer tablet a document that is titled misdemeanor plea admonishment. It's also labeled as State's Exhibit number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there are 2 sets of initials. First set of initials is on a line next to a box that's checked. Guilty, did you place your initials in this location?
Yes, sir.
Second set of initials are on a line next to a box, next to a line that's a statement that reads, I do not request discovery. In this case, I choose to enter a plea of guilty and no contest. It's basically saying that you're waiving your right to discovery and you're choosing to enter a plea of guilty and no contest.
Yes, sir.
On the next document, on the next page of the same document, there's a signature above a line that's titled defendant. Is this your signature?
Yes, sir.
And on the next document, that's titled trial court certification. All right, trial certification of rights to defendants without a trial certification of defendant's right of appeal. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. First box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
Now, Ms. Jones, before you signed and initialed all of the documents that I showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Ms. Jones, are you a citizen of the United States?
Yes, sir.
State, would you like to offer State's Exhibit number 1?
So attended, Your Honor.
Ms. Jones, the state is offering State's Exhibit number 1. State's Exhibit number 1 is the first document on this tablet. Hold on a minute, did it write the offense? Yeah. The first document on this tablet, same document that you acknowledge, that you recognize. This is the same document that has your signatures on page 2 and your initials in the 2 locations. And it is the same document that has your signature on page 3. Now, the state would like to use this document as evidence against you in your case. Is it all right for the state to use this document as evidence in your case? Okay, no objections. State's Exhibit number 1 will be admitted. Now, Ms. Jones, is there any evidence that you are currently mentally incompetent to stand trial?
No, sir.
Okay, Ms. Jones, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
After thorough review of the facts of the case and in due consideration of Ms. Jones' situation, Your Honor, we believe that 6 months deferred adjudication with a $50 fine and 24 hours community service would be appropriate and just in this matter. Is that correct, Ms. Jones?
Yes, sir.
What's the court cost?
$277.
Okay, now, Ms. Jones, the state is offering that you serve 6 months deferred adjudicated probation. During the 6 month probationary period, you'll be required to pay a fine of $50 plus court costs of $277. You'll be required to pay a probation fee of $60 a month, your analysis fee of $15 a month, and reimbursement fee of $15. Now, your total monthly installments, that is the total amount that you will be required to pay each month while you're on probation, is $158 a month. Will you be able to pay the $158 each month?
Yes, sir.
You'll also be required to perform 24 hours of community service, and you're required to adhere to the other standard terms and conditions of this probation. Now, Ms. Jones, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just? Do you accept the state's offer?
Yes, sir.
Now, Ms. Jones, I'll follow the plea bargaining agreement that you have entered into with the state. Now, Ms. Jones, if you successfully complete this probationary period, this case will be dismissed. It will not result in a conviction on your record, and you may qualify for non-disclosure, whereby your record will be sealed to the general public.
Yes, sir.
You can talk to an attorney about the non-disclosure. Now, Ms. Jones, you'll stand next to the bailiff, follow her directions. Once you finish following her directions, you'll be free to go, and you have a blessed day.
Yes, sir. Thank you very much.
You're welcome. Jefferson County Court at Law Number 2 is back in session. Court is in session in cause number 26 CCCR 0390. The case is styled the state of Texas versus Ronald I. Barnes. Mr. Barnes,
Yes, sir.
is that your full name?
Yeah.
Mr. Barnes, would you please raise your right hand? Mr. Barnes, do you swear affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yeah.
Mr. Barnes, you may put your hand down. How are you doing, Mr. Barnes?
But you,
Oh, I'm doing fine. Thanks for asking. Now, Mr. Barnes, I have before me, well, first of all, Mr. Barnes, you have a right to have a court reporter to dictate everything that's being said in this proceeding. You also have a right to waive or give up your right to have a court reporter to dictate or type down everything that's being said. Do you waive or give a right to have a court reporter?
yeah,
Okay, now, Mr. Barnes, I also have before me on paper a document that is titled Judge's Explanations of Rights to Defendants Without Attorney. Do you recognize this document?
Yeah,
Is this your signature
yeah,
on the line that is titled Defendant?
yeah,
And are these your initials on the line that state you like to waive your right to an attorney and represent yourself?
yeah,
I also have another document that is titled Waiver of Counsel for Purposes of Entering Guilty Plea or Proceeding to Trial. Do you recognize this document?
yeah,
And is this your signature on the line that's titled Defendant?
yeah,
Before you sign and initial these documents, did you read the documents?
yeah.
Did you understand what you read?
Mhm.
And is everything in these documents true or correct to the best of your knowledge?
Yes,
Okay, Mr. Barnes, I also have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Ronald I. Barnes, on or about March 2nd of 2025,
mhm,
while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of driving without a license, or driving with license invalid with prior or previous convictions, suspensions without financial responsibility.
yeah,
Do you understand what you have been charged with?
mhm,
And to this charge, how do you plead? Guilty, not guilty, or no contest?
yes,
Are you pleading guilty freely and voluntarily?
yes, sir.
And are you pleading guilty because you are guilty?
Yeah,
Mr. Barnes, I also have before me on my computer tablet a document that is titled Misdemeanor Plea Admonishment, is also labeled as State's Exhibit number 1.
mhm,
Do you recognize this document?
yes,
On page 2 of this same document, there are a set of initials, 2 sets of initials. First set of initials are on a line next to a box that's checked guilty. Did you place your initials in this location on this document?
yes,
Second set of initials are below, or actually was below a paragraph that's titled Discovery Admonishment. It is next to a statement that states, I do not wish to have discovery, in this case, I waive my right to discovery and choose to enter a plea of guilty, no contest. You place your initials, second location.
yeah,
On page 3 of this same document, there is a signature above the line that's titled Defendant Signature. Is this your signature?
yes,
And on the next document, that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
yeah,
And is this your signature on the line that's titled Defendant?
yes,
Now, at the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
yeah,
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
yes,
I also, now, Mr. Barnes, before you sign and initial all of the documents that I showed you,
mhm,
did you read these documents?
yeah,
And did you understand everything that you read?
yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes,
Mr. Barnes, are you a citizen of the United States?
yes,
State, you like to offer State's Exhibit number 1?
So tender, John.
Now, Mr. Barnes, the state is offering State's Exhibit number 1 to be used as evidence in this case. State's Exhibit number 1 was the first document that I showed you on this tablet. It's the same document that had your initials on page 2, first initials on the line that says guilty, And the other set of initials was next to a statement that read, I do not wish to have discovery. I waive my right to discovery in this case and choose to enter plea of guilty, no contest.
Right.
And it had your signature on page 3. Is it all right for the state to use this document as evidence in your case?
Yes.
Okay, no objections. State's exhibit number 1 will be admitted. Mr. Barnes, is there any evidence that you are currently mentally incompetent to stand trial? No, all right. Now, Mr. Barnes, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
It would be 3 days time served, judge, time actually served. And the state also requests that all court costs and fines be taxed and retired. Is that correct, Mr. Barnes?
Yeah.
Okay, Mr. Barnes, the state is offering that you serve 3 days in the Jefferson County Jail, but you would not have to serve any time in the Jefferson County, any more time in the Jefferson County Jail, because you've already served 3 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you have already served. The court costs in this case will be taxed and retired. That simply means that you will not be required to pay the court costs because the time that you have spent in jail has already paid off the court costs. Therefore, the court costs will be taxed and retired. Mr. Barnes, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just? And do you accept the state's offer?
Yeah.
Mr. Barnes, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Barnes, you'll stand at the end of that table, follow the directions of the bailiff. Once you're finished following her directions, you'll be free to go, and you have a blessed day. Stand at the end of that table. Here you go. Federico Vito Maselli.
Thank you.
All right.
Here,
See what?
That's better, just step over there. More as I have. You think you have something? What else? You say you have more. I don't have a printout.
I gave you when,
Yeah.
when Warren wasn't
He was candid enough. I think he's concerned about not having, I'm talking about Mr. Barnes. I told him I wasn't showing anything. I don't know, the JP City.
We don't have anything on our
No, sir.
system.
No, not that he has a warrant.
I you just wanna go to jail, I mean, we can't help you with that.
I'm not sure you have a warrant, so
Okay,
it might be city.
Yeah, check municipal court
oh, you said, oh, I need to send sign this one back.
on Orleans. We didn't sign it last time.
Yeah, was it city court?
Yeah, cause it's not here, we don't have.
You good in here?
Okay. Oh. So. Oh, the thing is stuck. This pen keeps hanging up.
Ready to- Yeah, we- no. Mm-mm. This is wrong. I'm gonna try this one. No. Try this again.
Thanks. Okay, court is in session and clause numbers 24 CCCR 3013. Clause number 25 CCCR 2803. And clause number 25 CCCR 2982. All three cases are filed in the state of Texas versus Federico Vito Maselli. And Mr. Maselli, is that your full name?
Yes, sir.
Mr. Maselli, would you please raise your right hand? Do you swear, affirm, to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, Mr. Maselli, you may put your hand down. How are you doing, Mr. Maselli?
Pretty good today.
That's good. Now, Mr. Maselli, I see these three cases was transferred from county court at law number 3 in Jefferson County, Texas. Is that correct?
I believe so. I did go to the other courtroom last time.
Right.
What was the reason for the transfer?
I have, well, it was just transferred. I don't have that motion before me.
Okay.
Let me do this now, Ms. Maselli. I have before me two documents. First document is titled Judge's Explanation of Rights to Defendant Without Attorney.
Yes, sir.
Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that states that you like to waive your right to an attorney and represent yourself?
I did.
I also have another document that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Now, Mr. Maselli, before you sign and initial these documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Maselli. I need to give you what is called a Faretta warning or admonition. It is from the case of Loretta versus California, 422, United States Supreme Court, 806. Now, I need to ask you some questions. Have you ever studied law?
Not officially, no.
Okay. Have you ever represented yourself in a criminal action,
Is that a current?
criminal case?
Yes, sir.
And do you understand the charges that have been filed against you?
I believe so. It's been a while. I'd like to hear them again.
Okay, well. You have clause number 24 CCCR 3013. In that case, you're charged with criminal trespass. And in clause number 25 CCCR 2803, you're charged with criminal trespass of a habitation. And clause number 25 CCCR 2982, you're charged with tampering with identification numbers. Okay. Now, you're aware of the maximum penalty range of these cases?
Yes, sir.
Okay. Do you realize that if you are found guilty of more than one of these crimes, this may result in an order that the sentences be served consecutively?
Yes,
That
sir.
is, one after another.
Yes, sir.
Okay. Do you realize that if you represent yourself, you are on your own?
Yes, sir.
Now, as a judge, I cannot tell you how you should try your case or even advise you as to how to try your case. You understand that? I cannot help you in any way.
Yes, sir.
Are you familiar with the Texas rules of evidence and Texas case law?
Yes, sir.
Do you realize that the Texas rules of evidence and Texas case law govern what evidence is admitted?
Yes, sir.
Okay. And in representing yourself, you must abide by those rules.
Yes, sir.
For example, do you know how to conduct a voir dire examination?
Yes, sir.
Okay, what is a voir dire examination?
I'm very well at this process.
I'm asking you a question.
I don't know how to really explain it, but I know.
If you can't explain it, how do you understand it? What is a voir dire? That's not, you don't have to explain anything to them, just ask you simply a question. Either you know it or you don't, that's all I'm asking.
I know the layman's terms.
What's the layman's term?
Well, what's another word for it? I'm very bad on the spot. Another
Okay,
word for dire would be,
you ask me, I'm asking you the question.
I'm asking you a different question. I asked you, what would be another word for dire?
Well, I'm getting the impression you don't know what a voir dire is, and you're trying to get me to answer what a voir dire is. I asked you the question, what is a voir dire?
I don't know that.
Okay, that's fine. That's all I need to know. Do you know what are the grounds for excusing a juror for cause?
That would be, why I believe one of the jury members shouldn't be in there. So yes,
Okay. And do you know what is hearsay?
hearsay is, it's coffee table talk. It's things that he said, she said stuff. There's nothing, no hard evidence or factual behind it.
Okay. Do you know what are some of the exceptions to hearsay?
No, sir.
Okay. Do you know what is the proper grounds for impeaching a witness?
No, sir.
Okay. Do you know when character evidence is allowed?
Depending on the case, sure.
Okay. Do you know when and how to make proper objections?
Yes, sir.
Do you know when and how to move for a directed verdict?
Not completely.
Okay. Do you know how to offer evidence to protect the record for appeal?
Yes, sir.
Okay. Do you know the proper grounds for a mistrial?
Yes, sir.
Are you aware that the failure to timely move for a mistrial may waive crucial mistakes made by the state or this court?
Yes, sir.
Do you know how to request and object to jury instructions?
Yes, sir.
Okay. Are you familiar with the Texas Rules of Criminal Procedure?
Yes, sir.
Okay. Do you realize that those rules govern the way in which a criminal action is tried in court?
Yes, sir.
Okay. Now, I must advise you that, in my opinion, you would be far better defended by a trained lawyer than you can by yourself. I think it is unwise for you to try to represent yourself. You are not familiar with, my opinion, with the law. You're not familiar with the court procedures. You're not familiar with rules of evidence. I would strongly urge you not to try to represent yourself. Now, in light of all the penalty that you might suffer if you're found guilty, and in light of all the difficulties of representing yourself, is it still your desire to represent yourself and to give up your right to be represented by a lawyer?
I heed your warning and, yes, sir, I want to represent
Okay.
myself.
Can we visit with that, Your Honor, that, of the criminal trespass to the resident, Your Honor. I'd like to see what the bond conditions are, if they've been previously set in that case.
I
what
am
are they?
on, I am on bond for all three.
Okay,
But
hold
I'd
on,
like to take a look because specifically,
hold on, let me see.
this is of a domestic, nature, criminal trespass to Danielle Masellis after their daughter called in.
Okay, well, let me see what's in here. Hold on a minute. Okay,
Just so the court knows, I haven't had contact with Ms. Maselli in almost 6 months.
okay, let me do this. Now, Mr. Marcelo,
Yes, sir.
your right to remain silent. Anything that you say can and will be used against you in a court of law. Your right to have an attorney. Before and during any questioning. Okay, let me do this here. Let me see which one is that. Let me see if it says on any one of them. This is his first court date. If let me see if they gave him bond conditions at the jail. Or even county court at law number 3. Order notice.
Use my address real quick, Karen.
You made you use your what?
My address.
Yeah, you can stand over there. Yeah, you can use notice of referee setting. I don't see internal transfer order rescinding appointment notice, appointment of counsel notice. I don't, hold on, let me go look at that, look at another one of the cases.
Ma'am? No, thank you.
Let me look at the other set. Oh, United States.
It's transferred.
Hold on, I'm looking this, let me see, I see a magistrate sworn in right here, hold on. Sometimes he has a note at the end of the magistrate sworn in. You know, and that's when he did. Who was that judge? PC. Was that Collins?
The other courtroom. You know, the other courtroom. Next door, do they deal with the prisoners here?
Well, they do the same thing.
This whole court deals with,
So they go in both courtrooms?
uh-huh,
All right, I didn't know if only this courtroom dealt with the jail, because I had 2 charges and then they put them all together when I went to jail. Because I had 2 or 3 different court dates, and then when I went.
I don't see none.
Oh,
There's none on the, tampering.
I don't see any bond, criminal doc.
If the court would also,
Yeah,
in jail when you went to the court next door.
No, I had 3 different court dates, and then I got arrested for something else. And as I was in jail waiting on accusation for that, they put all my court dates in the same roster. And the charge that I accusationed out on.
okay.
District
Hold on, let me
Attorney
take a look at the
decided not to take up.
03. Let me see, that's 03 and 82. Let me look at 03.
The-
03 would be the
that's the trespass to.
the habitation. Yeah, let me
Correct.
look at that. Let me look at the P.
Yeah, yeah. I was in here to visit you.
Okay, hold on. Dispatch homeowner, then that's silly. Scared to go. Okay, utilize the original, having prior notification. What do the having prior, that this entry onto law? Okay.
But I urge the court to
Yeah, let me see.
notice that date, Judge, and look
Okay,
at
hold on, let me see.
the tamper with the
Let me
identification.
see. 1109.
Mhm.
Okay, 6. Okay, hold on a minute. Okay.
Girl, girl, I sent out a link. What is it? It is another.
A week of the trespass to the residence of his wife and daughter, he was found with an AR-style rifle, 51 rounds, 2 magazines with an obliterated serial number. And I realize that I'm here in Texas, Judge, to where a firearm with an obliterated serial number is merely a Class A misdemeanor. But the different jurisdictions where I'm used to practicing is a mandatory minimum. Your Honor, I'm being candid, of 15 years, you don't have a firearm with an obliterated serial number. Not a week after, just want to bring the court's attention to, while it's a Class A in Texas, I'm concerned about the proximity, the amount of rounds within a week of the criminal trespass to the wife and daughter. So I'll just point that out to the court.
Okay.
You can
Yes.
speak.
I believe that I understand where you're coming from 100% on all that. But if you look at the paperwork, I was picked up on the trespassing charge at, I forget what date. And the firearm was taken before that as evidence, because the officers didn't understand it or know what to charge me with at the moment. And the DA sat on the gun charge for months, maybe 5-6 months before they filed. I bailed out on the gun charge and then y'all picked it up. No, I didn't pay bail. I did. I paid bail on that. And then, but it was picked up months later. That I sat for accusation on that gun charge and then I got picked up on it and I bailed out on it. So it looks like it all happened right then, but it was totally different incidents.
No, I mean, I see it's totally different incidents, but I see that the first trespass allegedly occurred on November 9th of 2024.
Yes, that
The
one.
second trespass of a habitation allegedly occurred on September 26th of 2025. And then the alleged tampering with identification numbers occurred a week or two after that, October 5th, 2025. Okay.
Either or, I understand where you're coming from, but since then, all that, there is an order of protection against me from my wife, soon to be ex, in a different state. All my guns have been confiscated. I'm playing it all by the book.
Okay. Well, we're gonna give you, some bond conditions in
Sir.
these
They said
three
you do
cases.
well to have a lawyer. I'm not
I'm just a
whispering
little
under
slow
my
on the
breath.
process, but I fully understand my rights. I get a little messed up on order of operations and language, but I'm certain that I can get through this. We can get through this.
Okay. So, let me do this here. So is it, your decision entirely to voluntarily, now let's see. Let me just read this. In light of the penalty that you might suffer if you're found guilty, and in light of all the difficulties in representing yourself, is it still your desire to represent yourself and to give up the right to be represented by an attorney?
Yes, sir.
And is your decision entirely voluntarily on your part?
Yes, sir.
Okay, so the court find that the defendant has knowingly and voluntarily waived his right to counsel, and I will therefore permit him to represent himself in these cases. April. Now your cases will be reset to give you time in which to prepare on your cases. The state will, now your case is gonna be reset for what is called an announcement. On that day, you come back and you announce to the court what you want to do in your case. For example, whether or not at that point you're ready to go to trial, or you need more time to get discovery, the evidence in the case.
Yes, sir.
Or maybe you need more time to prepare for trial. Okay, so make a copy of this here. I need to get that copy. I'm going to go over some bond conditions with you
Yes, sir.
in these cases. You'll be given a copy of the bond conditions that I'm going to go over with you.
Now, are these new bond conditions, or are we just going over there with it standing, so I understand?
There's no bond conditions.
Okay,
No, I haven't given you any bond conditions. I looked in your file and didn't see any bond conditions.
okay,
I know there's a standing order that the courts in Jefferson County have, but I'm going to give you bond conditions, specific bond conditions in this case. Ms. Mosby, could you hand this document to Mr. Maselli? For Mr. Maselli, that first document, well, the document is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that?
one more time, sir?
It's titled Standard Bond Conditions in County Court at Law Number 2. Do you see that title?
Yes, sir.
And it states, following return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds are executed for release of any defendant named herein are ordered subject to the additional conditions.
Yes,
Number 1, the defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition?
yes, sir.
Number 2, you're welcome. Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition, what's the wife's?
Danielle.
Hey, how's this?
DANI.
DANI
ELLE.
DLLE. Maselli.
MAS.
Oh, I know how to spell that. I'm looking at Maselli. Okay, and condition number 3, the defendant shall now communicate either directly or indirectly with the alleged victim, Daniel Maselli, of the spending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim, Danielle Maselli. Do you understand that condition?
Yes, sir.
Condition number 4 does not apply. However, condition number 5 does apply. Condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn, full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
And condition number 7 states the defendant shall wear a global positioning monitoring system, commonly referred to as GPS, device at the defendant's expense with written verification being submitted to the court within 3 days. Do you understand that condition?
So I'm getting an ankle monitor.
Yes.
Okay,
Okay, and she'll give you your reset and locations where you can get it. Now, if you violate any one of these bond conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand?
yes, sir.
Okay, please.
Yeah. Put it right there.
Okay. I have
No.
is your reset is over there? Okay.
Yeah.
You can get your reset. Once you get your reset, you're free to go. And you have a blessed day. And when you get a copy,
Question I had, I mean, I don't see here, but with the ankle monitor, I'm free to leave Jefferson County, correct? Like,
well, we don't have no bond conditions that on that's restrict you to a geographical location.
okay,
Okay,
yes, sir. Thank you.
all right.
Then there's
But you can check with your bondsman, as well.
Ma'am?
that list tells you where to get your,
And you need to bring proof here back to court, or if you,
3 days,
yes.
Okay.
Okay,
and we are set for
oh,
5:15.
it's 5:15, but you're gonna have to make an appointment with the district attorney's office to get discovery in the case.
Yes, sir.
Okay, are you the prosecutor in the case? Or is it
I'll
her?
be the prosecutor in the case, I don't.
I was gonna call in the morning and take care of that, or can we?
He have to set an appointment.
But you can just give a call.
I'll give a call in the morning and see when they are available,
Okay,
have the file together.
okay, where's his paperwork? Oh,
we're good.
this is Elijah Malbro?
Yeah. Hold on.
That's not a plea, it's a appointment.
That's you?
Uh-huh. But uniform and I can have the investigate or assist, call and set an appointment.
I need some bond conditions.
Thank you, sir. I'll have a blessed day.
You're sorry.
Okay, Mr. Malbro? Mr. Malbro, would you please raise your right hand? You swear firm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Malbro, you may put your hand down. How are you doing, Mr. Malbro? I'm doing all right. Now, your full name is Elijah Malbro. Is that correct?
Not including my middle name.
What's your middle name?
Trey.
Jamar Trick?
Jamar Trey. Jamar Trey.
Jamar Trey.
That's it.
Okay, so it's Elijah Jamar Trey Malbro.
That's it.
Okay. Now, let me do this here, Mr. Malbro. First of all, Mr. Malbro, you look good today. You dressed all up?
And
Okay. I see, that's a product of good home training. Okay. When I was a young man, they used to tell us, dress for success. Okay. And so, I don't know. I know sometimes when you get dressed up, you feel good about yourself. It has effect on your attitude.
Yes,
right? That's a good thing. That's a good thing. Let me see, the day is the 14th, right? 2026. Now, Mr. Melbro, I have before me two documents. The first document, hold on a minute, let me pull up your case. Melbro. Yes. I'm gonna need a copy of this. Yeah. Now, Mr. Malbro, I have before me a document that is titled Jefferson County Affidavit of Indigence, and another document that is titled Judge's Explanation of Rights of Defendants Without Attorney. Now, did I swear you in?
Yes, sir, Judge.
Okay. Now, Mr. Malbro, the first document, Judge's Explanation of Rights of Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes, it is.
And are these your initials on the line that state you'd like to apply for a court-appointed attorney? I also have a document that's titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that is titled defendant signature. Is this your signature?
That is my signature.
Now, Mr. Malbro, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
I understand.
And is everything in these documents true and correct
Yes, sir.
to the best of your knowledge?
Yes, sir.
Mr. Malbro, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in this case is Ms. Marver or Attorney Marver Provo. Attorney Provo will be given information to contact you, and you will be given information to contact her. Our court coordinator will give you that information. But before she gives you that information, the bailiff is going to hand you a document that is titled Standard Bond Conditions in County Court at Law Number 2. And I'm going to go over this document with you. You see that title, Standard Bond Conditions in County Court at Law Number 2?
Yes, sir.
And it states, following return of criminal information in County Court at Law Number 2, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol when the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim Fantasia Marks of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim Fantasia Marks. You understand that condition?
Yes, sir.
And condition number 4 does not apply. Condition number 5 does apply. Condition number 5 states that the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged employment in employment as a sworn, full-time, paid employee of a state agency or political subdivision. And Mr. Malbro, do you understand that condition?
Yes, sir.
Okay, now, Mr. Malbro, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest and you'll be arrested and placed in Jefferson County Jail. Do you understand?
Yes, sir.
Okay, let me hold on. Okay. Now, Mr. Malbro, your case is going to be reset to give you an opportunity to meet with your attorney and give your attorney an opportunity to get the evidence from the state and also talk and have a conference with the state as well and investigate the case, okay?
Yes, sir.
So your case is going to be reset. Once your case is reset, you'll be free to go. And you have a blessed day. Mr. Malbro, I see that you're not here. You getting ready to say something?
No, sorry about this. I said yes, sir. I heard it the first thing you said.
Oh,
Have a blessed day. I was telling you, blessed day too.
okay. Well, thank you. Now I see that you're not here alone. You're here with some folks. Who are you here with?
Well, I'm here with-
Who are you here with? Yeah.
That's my mom and my stepdad.
Okay. Thanks for coming down here with your son. Mr. Malbro, how old are you?
22 years old.
Guess what? You probably wouldn't believe this. I used to be 22 for 365 days. Okay. And when I was 22, I had friends, right?
Yes, sir.
And and I know you have friends too. You these days you call them your BFF, best friends for life, or your ride or die. No, in my day, we used to call them our ace boom coon. Those was individuals that we figured, would be with us through thick and thin, and when we're down and out, they'd be there to pick us up. But, on days like today, that person that you call all those persons that you call your BFF or your ride or die, they're not here today. But you had your parents here today. Those people that you call your BFF if you ride or die, they had something better to do than to come down here with you in court, to be with you in court. But your parents who are here today, there was nothing in this world that could stop them from being here with you in court today. You know why? They love you. That's why. I'll tell people this all the time. Everybody is not your friend. Everybody's not your partner. But when them two people say they got you, they got you. Okay? And you could take that to the bank. All right? Because I know there was the people that put a roof over your head, put clothes on your back, and you look real nice today. And they put food on the table. They did all those things because they love you. And I know every now and then they probably had to put a little spanking on your butt. And that was because they love you too. And so, this is not the proudest day of their life. Seeing you here before a judge in a black robe. But you might even think that, your life is over, I'm in a storm. I don't know what to do. But guess what? Remember this. When you're walking through a storm, hold your head high. Don't be afraid of the dark. At the end of the storm, there's a golden sky and a sweet silver song of lark. Walk on through the wind, walk on through the rain, though your dreams be tossed and blown. Walk on with hope in your heart, and you'll never walk alone. There's one thing about hope. Hope floats. So when you're drowning in the sea of confusion, and I say when, I'm not saying if, but when? Because in life, we all have ups, downs, trials, and tribulation. Every day is not sunshine. Sometimes we have rain and we have storms in our life. But when you're drowning in the sea of confusion, just hold on to hope, hope floats. It'll keep your head above water. Okay? And some people might look at this and say, oh, he didn't ruin his life. This is a stumbling block for him, but you could look at it as a stepping stone. And people use stepping stones to reach higher heights. I've said that to say this. Anything that you want to accomplish in life, you still can. Okay? You just have to put this behind you, change your behaviors, and be the man that those people know you can be, that they brought you up to be. Okay? So before the day is over, you need to get that woman sitting back there with that white hat, a big kiss. And you need to get that man right there with that black on, a big hug for being down here with you today. All right. Folks, just thanks for coming down here and supporting him. Don't hang up, hang on to him. All right. Gonna get your reset. Once you get your reset, you're free to go and you have a blessed day.
Thank you.
All right. All right. Oh, I didn't give you papers.
Did he get bond conditions? Oh, okay.
I did. He got
He
it right
gave bond
there.
conditions.
GPS?
No, he didn't have a GPS.
Oh, okay, thank you.
Not on his.
Okay, you get everything.
Go ahead on the call. Okay, court is back in session and call number 26 CCCR 0406. Case is style of state of Texas versus Lorenzo Aston Thomas. Lorenzo Aston Thomas was scheduled to be in court this morning at 9 a.m. At or about 9 a.m., The court's bailiff called the name of Lorenzo Ashton Thomas at the courthouse door. Lorenzo Thomas did not answer. Is not appeared in court since the court has been in session. The time now is 12:30 p.m. on today's date. Miss Bailiff, would you please call the name of Lorenzo Ashton Thomas at the courthouse door? Yes, Lorenzo Thomas. Okay, Lorenzo Thomas' name was just called again at the courthouse door. Lorenzo Thomas did not answer. The reasonable time has passed to give Mr. Thomas an opportunity to appear in court. He is not appearing in court. State, do you have a motion?
Yes, Your Honor, the state moves to forfeit the bond and warranty issue, Judge.
Okay, that motion will be granted. Lorenzo Thomas' bond will be forfeited and warrant shall be issued for his arrest in cause number 26 CCCR 0406. Next case is cause number 26 CCCR 0474. Case is styled the state of Texas versus Chastity Caesar. Chastity Caesar was scheduled to be in court this month. Huh?
James Patrick was hard on me.
Oh, okay. Okay, that's Houston. Okay, this will conclude the calling of the court's arraignment docket on today's date, April 14, 2026. In County Court at Law Number 2, Jefferson County, Texas. Judge Terrence Holmes presiding. Court will be in recess until we resume with the trial at 1:30. Okay, prosecutors, excuse.
Thank you.